Good morning, everyone, and welcome to the January 2021 docket of the Kansas Court of Appeals. Before we get started this morning, I'd like to take a minute to introduce our panel members. Uh, Joining us today is Judge Anthony Powell, who has served on the Kansas Court of Appeals since 2013 and hails from Wichita. And he also spent 10 years on the district court bench in Wichita. And then also with us is Judge Patrick McInerney from Johnson County. And Judge McInerney served as a judge on our court for 15 years before retiring in 2019, but of course he couldn't get away. And so since that time, he's been serving as a senior judge on our court. And before he joined the Court of Appeals, he served on the Johnson County District Court. I'm Sarah Warner. I am the presiding judge today, and I'm the newest member of the Kansas Court of Appeals, joining in 2019 after being engaged in private practice in Lawrence. So I'll be keeping time for today. We have had the opportunity to thoroughly read your briefs and your arguments. We're familiar with the facts of your case. But for the sake of the public who might be observing these arguments, I'm going to give the appellant an extra 30 seconds to a minute at the beginning of his argument to briefly explain how we got here today. So with that, I'm going to call the first case on this morning's docket. That case is case number 122278, Dalton Joseph versus the Kansas Department of Revenue. Would the attorneys please state their appearances?
May it please the court, counsel. My name is Barry Clark, and I represent the appellant, Dalton Joseph.
May it please the court, I'm Jay Van Blaricum, representing the Kansas Department of Revenue.
Thank you. This case is scheduled for 15 minutes of argument for both sides. Mr. Clark, would you like to reserve any of that time for a rebuttal?
If I could have 3 minutes, please.
3 minutes are granted. And with that, you may begin.
Thank you. May it please the court, counsel. By synopsis, this case is a driver's license suspension case that stems from my client's arrest for driving under the influence of alcohol in Riley County, Kansas. We have challenged that suspension, tried it before the district court in Riley County, and now bring it before this court for review. Judge, the basis of my argument is actually quite simple. I'm going to rely primarily upon the brief. My client was arrested for driving under the influence of alcohol. He was under the age of 21 at the time. He was transported to the Riley County Police Department, where he was asked to submit to a breath test, and he complied with that with a result that was greater than 0.08. A driver's license suspension was instituted, an administrative hearing was conducted, and we tried the case on petition for judicial review before Judge Bannister in the Riley County District Court. At that time, the Department of Revenue, the basis for our petition for review is we believe that there was not probable cause to arrest my client for the offense of driving under the influence. And that's the crime that he was arrested for. At the hearing, my opponent proposed to the court that the Bixenman case controlled this matter. And Bixenman, as the court will recall, stood for the proposition that although ordinarily under KSA 81001B, there must be a lawful arrest or a motor vehicle accident before you can request testing. And in this case, there was no motor vehicle accident. That the ordinary prerequisite of an arrest for breath testing does not apply. And that's because in this case, and we concede the evidence clearly established that my client had alcohol in his system and he was under the age of 21. The problem is that we believe that Bixenman is in direct contradiction with KSA 81001B, which states that in the event that an officer wishes to request testing, either because he believes that the suspect is under the influence of alcohol, or that the person is under 21 and has alcohol in his system, that one of the following conditions must exist. Either the person has been arrested or otherwise taken into custody, or involved in a motor vehicle accident. So what we really get down to here is, must the court determine that there's been a lawful arrest, even in the case of an underage driver? We believe that is in fact the case. As I stated in my brief, my client was arrested in this case. He was arrested for driving under the influence. And under the Sloop case, we know that any request for testing must be preceded by a lawful arrest. And we asked the court to determine whether or not there was probable cause to make my client's arrest. And Judge Bannister found that there was probable cause to believe that my client was under the age of 21 and that he had alcohol in his system. And we don't challenge those findings. Those are supported by the evidence. The problem is KSA 81567A is civil in nature. It is not a criminal statute. It is a purely civil statute. And we believe that the officer in this case does not have the power to arrest someone for that civil infraction. Under the arrest statute, KSA 222401, law enforcement officers' powers of arrest are limited. One, they have to have. Yes, ma'am.
Clark, I want to interrupt you. What is the basis, or what was the basis for your argument that there wasn't probable cause to arrest, putting aside the fact that your client was under the age of 21? What was the basis for arguing that there wasn't probable cause to arrest to begin with?
Well, there was no erratic driving in the case. There was the stop was made for a traffic infraction, crossing a center line during the course of making a turn. The vehicle remained. My basis was there was no probable cause to believe my client was driving under the influence. I mean, that's the basis in direct, if you want a direct response. We believe the evidence didn't support that. Now, Judge Bannister was in a bit of a jam because we previously tried the same issue in a criminal case, and he found there was no probable cause on the criminal prosecution. But we believe that my client passed one standardized field sobriety test. He failed one. And the balance of the evidence in the case did not supporting a finding that he was driving under the influence of alcohol. That was our challenge. Judge Bannister never ruled on that issue. If you look at the transcript of the trial, he found that there was reasonable grounds or probable cause to believe my client was under the age of 21 and had alcohol in his system. That's not a crime. It's against the law in terms of a potential driving suspension, but it's not a crime.
And I just want to be clear in my mind. When you said that this case had been tried as a criminal matter, are you talking about the specific case before us? This is the license suspension side, but these specific facts had been tried to the court in the criminal matter?
Yes, in the criminal case. So this was kind of a do-over, if you will. The same judge tried the administrative case as tried the criminal case. So I asked Judge Bannister at the conclusion of the hearing specifically, are you determining that there's probable cause to believe that my client was driving under the influence of alcohol? And Judge Bannister declined to rule on that issue. He said, I don't need to get that far because under Bixerman, all I need to determine is that he's under 21 and he has alcohol in his system. And we agree, that's true. The problem is it's not a crime. And my client was handcuffed, put in a squad car, driven to the police department and subjected to testing. He was arrested, and we have the right to challenge the propriety of that arrest. Again, we think that 815-67A is not a criminal statute. I mean, the appellate courts have ruled on that. So you can't arrest him for that. You got to arrest him for something under 81001B. We also think our second issue that we raised is that Bixman just isn't controlling in this case. In the Bixman case, that licensee was given 2 field sobriety tests that he passed, a preliminary breath test that was greater than 0.02 but less than 0.08. He was arrested and taken downtown and given a breath test. In that case, he was suspended after being given a DC-28, which is the form that institutes an administrative action for driving underage with alcohol in your system greater than 0.02. That's not this case. I mean, this case, the officer certified that my client was driving under the influence of alcohol and tested greater than 0.08. So I'd be happy to entertain any other questions the court might have, but largely I'm going to rely on my brief.
You say this was originally tried by the same judge in criminal proceedings. Was that a de novo appeal on a municipal court conviction, or how did that arise? Do we have that in the record?
No, Judge. And I don't think it's something that can be considered by this court. I mean, each case stands on its own 2 feet. I just offer that by way of background.
Okay. All right. All right. Thank you.
And I have nothing further unless the court has other questions for me.
All right. Thank you, Mr. Clark. You still have 3 minutes for rebuttal.
Thank you.
Mr. Van Blericum?
May it please the court, counsel. Thank you. Really, I agree that this case does not squarely fall under Bixman, but under the totality of the circumstances in this case, if you look at the DC-27, which is the certifying document that the officer presented to the appellant, he listed both that he had reasonable grounds to believe there was that the appellant was driving under the influence, and that he believed that he was under 21 with alcohol in his system while operating a vehicle. He certified both of those, and he listed all of the evidence that he relied on to make that conclusion. Those are listed in my brief. He listed the odor of alcoholic beverages, sobriety tests indicated impairment. The officer here thought that the appellant failed both field sobriety tests. Slurred speech, bloodshot eyes, poor balance or coordination, and refused preliminary breath test. And it was after the preliminary breath test that the officer arrested the appellant for DUI. And I will note that it's correct that case law has discussed 1567A as being a civil statute. It contains no criminal penalties. However, the Supreme Court has explained in State versus Schuster 273 can 989 that 81567A prescribes underage breath or blood alcohol levels between 0.02 and 0.08, but it did not apply where the appellant's blood alcohol level was 0.10 or above. The Court of Appeals concluded that the DUI statute is not limited to drivers under 21 applied in that case. In this case, the blood alcohol level certified by the arresting officer was 0.153. So yes, this case does not fall under 1567A. It falls under the crime of DUI, which is applicable to anyone over 18. And the penalty is found in KSA 8-1001B, which is the the officer has reasonable grounds to test for alcohol in the system, and his
Counsel,
basis for believing.
counsel,
Yes.
we're a court of review, and so even if that were the case, and that the officer had numerous reasons why this arrest, why he believed that he had probable cause to arrest, we don't have any factual findings to that effect, do we?
The journal entry in the record says the officer was justified in arresting petitioner, conduct additional testing pursuant to KSA 8-1001A and B. It does not list findings of fact.
Is there any other location in the record where findings might be found?
Yes, the Judge Bannister made findings on the record. It's in the trial transcript.
All right.
Well, all those that you just recited, those were, didn't the court rule from the bench on this, in this case?
Yes, Your Honor.
And made findings, some of which don't relate, aren't evidence necessarily of any kind of violation. For example, simply drinking is not a violation.
Correct.
Drinking and driving is not a violation. It's being intoxicated. So, but he did make findings about the traffic infraction, about the bloodshot, watery eyes, speech slurred, all that kind of business. It's just what he did with those facts. That seems to be the issue.
Yes, Your Honor, I would submit that, as I stated in my brief, this case was a little confusing for all of us at the trial level. I'll admit that I was new to this area of law, just starting out in my trial practice with the Department of Revenue, and I didn't quite understand how the Bixman case applied. I understand more fully now after more research, the briefs, the appellant's brief. I would still submit that the district court made the correct decision, but even if the decision is found to be erroneous and Bixman does not apply to this case in particular, I still believe the Bixman case and its discussion of the evidence that's required to establish reasonable suspicion that a person under 21 has alcohol in their system such that they would violate either 1567 or 1567A, that justified the arrest, which the officer stated when he arrested the appellant. He said, "You're under arrest for DUI." And I think the district court, even if it stated reliance on Bixman completely, was not 100% correct. I believe that the decision should be upheld because probable cause was established in this case, and the court correctly ruled in favor of the department in finding that the appellant failed to meet the burden of proof of showing that the officer's certification was false.
Any other questions for Mr. Van Vlerkum?
None.
Counsel, do you have any other argument that you'd like to offer?
Judge, I would just state, Judge Warner, with response to your question to Mr. Van Vlerkum, I'm in complete agreement with that premise. Judge Bannister never found probable cause for driving under the influence. That was not his findings in this case. He found probable cause that my client was under the age of 21 and probable cause to believe my client had alcohol in his system. We don't disagree with those findings. The problem is that's not a crime that you can arrest somebody for.
But counsel, my question was, are there facts relating to the underlying conduct? Probable cause is, of course, a legal conclusion, right? But are there factual findings relating to the underlying conduct that the district court made? And would you agree that the district court made some findings regarding your client's eyes, the odor of alcohol, etc.
I do. I completely agree with that. But I don't think that this court of review is in a position to make a finding of fact that Judge Manister should have made in this case, which is, was there reasonable grounds to arrest for a crime? Those findings were never made.
Isn't that whole issue a mixed question of law and fact?
I agree.
And the question is whether there's substantial evidence to support his fact finding. And everyone seems to concede that there is evidence to support the fact that there was a traffic infraction, the bloodshot eyes, all that kind of business. And then isn't the ultimate question of whether this constitutes probable cause to arrest, isn't that a legal question for us to do independently of the district court?
I disagree, Judge. The findings made by the court were that my client had alcohol in his system and was under the age of 21. I mean, certainly, and we don't contest that. We asked the court to determine, was a crime committed that justified an arrest, and is there evidence to support it? And I think under 81001B, there has to be an arrest prior to breath testing. That's where I think Bixenman is a faulty decision. Thank you.
All right. I want to thank counsel for their arguments this morning. We'll take the matter under advisement and get an opinion out just as soon as we can. If everyone would hold on, we're going to go off YouTube, but then you can go on ahead and go your separate